Hello, and welcome to Better HR in 10 Minutes, where we take a question for HR and in 10 minutes or less, we discuss it from the point of view of a trainer and a point of view of a labor and employment law attorney. I'm the trainer, I'm Rodney Klein. I have over 30 years experience working with the U.S. Equal Employment Opportunity Commission and as owner of my own training firm.
And I'm the employment lawyer. I'm Sarah Glasser. I'm a shareholder at Lloyd Gosselin, Rochelle and Townsend in Austin, Texas, where I head up our firm's employment law practice group. Now, Rodney and I are talking today, and keep in mind that the information that we share is general information. It's not legal advice. There's no substitute for an attorney you have hired to represent you. Rodney, what's our question today?
Well, the last video we presented, we kind of suggested that there was a second part to the Groff Supreme Court decision. And so we were going to talk about that today. So I'm going to take just a minute or two to kind of frame the problem, and then I'm going to pitch you a scenario and see what you think.
Okay,
So let's
sounds like
say,
fun.
good. Let's say you're the employer and I'm the employee, right? And let's say I request a reasonable accommodation because of a disability. Now, the ADA says that if my disability or my limitations aren't obvious, you have the right to ask for confirmation from my physician to make sure that I actually do have those limitations. In other words, if I'm requesting an accommodation because I have a bad back, then you can certainly ask to confirm that I do have a bad back. The problem with that, with sincerely held religious beliefs, is that the law says that all sincerely held religious beliefs are covered even if I happen to be the only person in the world that has them. Now, that's a real problem for confirmation. In the past, before the Groff decision, when the undue hardship bar was so low, more than a de minimis, that was never really a problem because we could advise employers, hey, just take the stated sincerely held religious belief at face value because you'll deal with this as an employment decision later. We can either provide the accommodation or we can't. But now that that bar has been raised, there's a lot more things on the table. Now, I want to make sure I'm framing this correctly. Mr. Groff and people like Mr. Groff who have a sincerely held religious belief that needs accommodating are not the problem. They are not. The problem are people that don't really have a sincerely held religious belief but pretend they do because so they can get some sort of adjustment to their employment. So let me pose this scenario for you. Let's say you're the employer and an employee comes to you and says, look, they need Sundays off because they have a sincerely held religious belief that keeps them from working on Sundays. So you conduct due diligence and you decide that you can provide that accommodation without it creating an undue hardship. Great. But then 2 weeks later, 10 more employees from the same department come to you and they're all requesting Sundays off and they're all citing sincerely held religious beliefs. What do you do?
You really set up a difficult problem for a person. But I think as I'm listening to you talk about this, I keep thinking, oh, this is something that's important to talk about, and this is something we can talk about. So I'm going to kind of hit them in what I think is I don't know, that they're a little bit. It's kind of point. So the first thing is that I think we probably, for sake of your hypothetical, I think we probably have to kind of accept as true that 10 people did not just suddenly decide that they are going to take advantage of this right to accommodation that they have under Title VII. So let's, for the sake of conversation, assume that there are probably some of these, some accommodation requests which a person was like, oh, I didn't even know I had that right, I'm going to take advantage of it, and others which are, oh, this could work out well for me. So let's assume that to be the case. And so we're in a situation where the circumstances kind of lead us to believe that there may be some insincerity about at least some of these requests. And that's a big thing about Title VII and religious accommodation requests that I tell my clients in most instances is when someone comes to you with a request for accommodation related to religion, we typically give them the benefit of the doubt and that their religious belief is sincere unless they give us a reason not to. So I think that question number one is, does the fact that we received 10 of them give us a reason to question the sincerity of some of these things? I don't know the answer to that. I would think the circumstances at least cause us to have to look a little bit closer at that. But what you were really getting at, and then I'll turn it over to you to talk, is that there appears to be this kind of like pendulum switch or kind of movement in terms of what employers may focus on when they get a religious accommodation request. In other words, because this legal standard has changed for what's an undue burden, are we going to look more closely at the sincerity of a religious belief? And if we're going to do that, what is the framework for doing it? So I know you work through this with clients pretty regularly. So how are you changing what you're going to say to them?
I don't really have a great answer. And I think because the Supreme Court didn't really address it. And it's one of those things that they'll probably let sit there for a while and create some problems, and then they probably will come back and address it. But I don't really know that there's a whole lot of language in Title VII that allows employers to confirm. At best, that employers can do is refute. If we're talking about something like beliefs, that's almost a practical impossibility. Beliefs change, they're malleable, they change under conditions, and they can be wildly inconsistent, and all of that stuff is protected if it is sincerely held. So I think that's really difficult. The only way that I can see how to do this is do this through the lens of accommodations, and accommodations is individualized assessment. So ultimately, you have 11 people who are requesting this accommodation, and maybe you look at the first three and you decide that, hey, we can do this without it creating an undue hardship. But 4 through 11, oh yeah, that's an undue hardship. So you can deny those. Now, is that a good answer? No, because those 7 people will never, ever, ever understand why they didn't get that accommodation. So that's going to create problems within the department and within the organization. But that's really about the only way I can think to approach it, because I don't know of a mechanism by which you can, in a foolproof way, confirm somebody's stated sincerely held belief as being really sincerely held.
I'm with you. So talk about this for a minute, because this is a question that I get regularly. Is Sometimes when I'm talking through an accommodation request with a client, they'll say, well, if we grant this one, then we're going to have to grant it for every other person who asks. So yeah, let's talk about that.
Yeah, we trick employers, right? And we say, okay, when it comes to discrimination, consistency is the key. Oh, wait, except for that reasonable accommodation stuff. And the whole definition of an accommodation is something that is inconsistent. And so we have to adjust employers' thinking and the fact that, no, that's the whole point of an accommodation. You're not doing this for everybody else. And conditions change. And at some point in time, this starts creating an undue hardship. It creates an undue hardship. Again, that's not a great answer, because that's not going to resolve the fundamental issues that you have within that department. But it's the only one that I can think of. And I think it's just an implication of the Groff decision that we don't have a solid answer on, and maybe someday we will.
Well, I guess that's probably all we've got for today. Great conversation, and thanks to everyone for joining us.